So this ruling will ensure that every undocumented individual facing deportation has the opportunity to request cancellation of removal for a green card if they have met. Today, we have some great immigration news to cover. USCIS has announced that they will no longer require biometrics appointments for certain applicants. USCIS has also announced a return to the deference policy, which will speed up processing times for certain applications and those with employment-based visa renewals, and it will prevent them from getting unnecessarily denied. And finally, the Supreme Court has ruled in favor of an undocumented individual facing deportation, ruling that the U.S. government must give them a chance to plead their case and potentially earn a green card. We will get to the details shortly. Make sure you stay tuned until the end to see how this immigration news might impact your case. Also, please make sure to like this video so that others on YouTube get a chance to see it. And if you have not already done so, please make sure to subscribe to my channel and click that notification bell so you know every time I release a new video and when I go live. Starting on May 17th, USCIS will no longer require basic biometric screenings for spouses of certain work-based visa holders. This announcement is in response to a class action lawsuit that was filed, claiming that these requirements led to significant and unlawful delays. More on this in just a second. About 2 years ago, USCIS started requiring everyone who submitted Form I-539, the application to extend or change non-immigrant status, to complete biometric screening before proceeding on their case. This led to delays in processing these applications, as well as applications for the I-765 application for an employment authorization document, otherwise known as the work permit application. What are biometric screenings? Biometric screenings are done to get your physical data on record. This includes taking your picture, taking your fingerprints, and having you sign your signature. It is a standard procedure when applying for a green card, for naturalization, for asylum, or for other immigration benefits. The process is meant to confirm your identity and facilitate in criminal background checks. However, completing biometric screenings requires an in-person appointment, which is a time-consuming process for both USCIS and the applicant. The result has been an unreasonable delay in the processing time, causing many immigrants to lose their jobs. Class action lawsuits have resulted with large companies backing them, including tech giants such as Google. So what does this mean for your case? If you are in the H4, L2, E1, E2, and E3 categories, you have not yet received a biometrics appointment notice, and your I-539 application has been pending on or before May 17, 2021, then you do not need to attend a biometrics appointment. Hopefully, this will speed up the application process and help eliminate the backlog that this policy has created. This next piece of good news is a result of the Biden executive order issued in February. USCIS has announced that it will return to the 2004 deference policy, which was rescinded by Trump in 2017. The policy states that immigration officers should generally defer to prior determinations of eligibility when adjudicating extensions involving the same parties and facts as the initial application. When USCIS officers adjudicate an immigration case, it means they make a decision whether to approve or to deny it. After the Trump administration rescinded the deference policy, it forced USCIS officers to go through the process of re-adjudicating employment-based immigration cases that were simply applying for an extension. For an example, if an employer was filing to extend the non-immigrant status of an employee, which could be in H-1B, L-1, O-1, or other visa classifications, and there had not been a change to the case, USCIS was still required to extensively scrutinize the new application and make a second decision whether to approve or to deny the case. This has resulted in longer processing times and an increase in requests for evidence and illogical denials of cases that were previously approved and which had no changes since the approval. Now that the deference policy has been reinstated, USCIS can defer to previous decisions made on the case. That means that if there have not been any material changes to the case since it was last approved, a petition for extension can be completed without going through a lengthy adjudication process. The result will likely be a reduction in processing delays and backlogs for related case types, which will make the extension process less stressful for families and more reliable for businesses hiring these employees. Finally, what are the details of the recent Supreme Court case that ruled in favor of an undocumented immigrant? An undocumented Guatemalan individual recently fought his deportation in the Supreme Court of the U.S., alleging that he never received notification stating the charges or giving him a date to appear. The Supreme Court ruled in his favor, declaring that enforcement authorities must provide a clear notice to appear with all the relevant information rather than multiple documents spread out over time. Why does this matter? The ruling will affect potentially thousands of cases and immigrants facing deportation across the U.S. Under federal law, undocumented immigrants who have been present in the U.S. for at least 10 years prior to the notice to appear being served may apply for cancellation of removal and receive a green card if returning to their home country would cause exceptional and unusual hardship to their U.S. citizen parent, spouse, or child. Previously, if their notice to appear had been issued short of the 10 years of presence, even if it did not contain the time, date, or location of the hearing, then it would render them ineligible to request cancellation of removal and get a green card. So, this ruling will ensure that every undocumented individual facing deportation has the opportunity to request cancellation of removal for a green card if they have met the 10-year residency requirement, and this time would not be considered stopped by a defective notice to appear. While these changes will help to resolve some of the backlog and inefficiency in our immigration system, there is still much more that needs to be done. 5 immigration experts recently met to discuss the problems facing USCIS, the Department of State, the Department of Justice, and ICE. Click this video to hear what they had to say about the problems that we still face and that still need to be addressed by Biden and their recommended solutions for each of them. I will be releasing another video soon as more immigration news becomes available. If you have not yet subscribed, please make sure to do so now. Check out this video and see you next time.